So I want to thank first to start by thanking Sandra and Sean for hosting this really great conference and having me on board and joining the organization steering committee of this really excellent conference. And the first panel that I'll chair is a panel that is dealing with the future of IP and religion. We have a group of great scholars that I'll mention later on when we introduce them. The panel generally will discuss the future of IP and religion. We will consider current perspectives regarding the role that religion can play in developing modern IP law, examining scholarly trends in the study of IP and religion. We will discuss how different religions treat modern challenges to IP and the extent to which it can inform the development of future IP doctrine. I want to thank my co-organizer, Professor Tabrez Ibrahim from Lewis and Clark Law School, that helped me in putting together this panel, and he is also a speaker on this panel. So thanks so much for all the help. And I want to start by exploring IP through the lens of religion thought first, and then we can move on to our distinguished speakers. So I want to start by discussing the connection between religion and IP and how religious perspectives can inform approaches to challenging IP questions. While scriptures do not explicitly deal with IP rights, religious views underlie fundamental conceptions of IP theory. I'll focus on the scholars of faith to explore ways that religious thought can inform approaches to challenging IP questions. These scholars have applied religious perspectives to two primary categories of IP: patent law, particularly in the area of biotechnology, and copyright law. I'll highlight the work, inspirations, and methodologies of several scholars at the intersection of IP and religion thought, with a focus on Christian, Jewish, and Muslim perspectives. And as you are going to see, our panel is going to offer some really, I would say, fresh and new perspectives that haven't really been, I think, at the core of this scholarship. Let's start by looking at a Catholic scholarship. Professor Thomas Berg is a leading scholar in the field of IP and religion. His work has focused on the compatibility of IP and religious principles, particularly within the context of Catholic social teachings. He has organized conferences and workshops that have brought together scholars from various belief systems, promoting new scholarship in IP and religion. According to Professor Berg, the fit between IP and religion is a natural one, as both law and religion address issues of property, human dignity, and creativity. He argues that religious perspectives are particularly relevant to IP because religion tends to view intellectual creativity as a divine capacity that overlaps with human dignity. Moreover, religious insights can contribute to discussions of morality, human rights, and social justice, which are increasingly intertwined with IP rules. Professor Berg's seminal piece on IP and the preferential option for the poor advocates for a degree of skepticism towards broad IP rights, particularly in relation to pharmaceutical patents, as necessary to effectuate Catholic principles. He identifies several areas of IP protection where limits should be imposed based on prudential judgments derived from Catholic thought, including limits to enable access to essential needs for education and other non-commercial purposes for technology transfer and to encourage innovation. While Professor Berg's work focuses primarily on Catholic approaches to IP issues, his insights are relevant to scholars and policymakers across belief systems. His analysis through the lens of religious principles provides a distinct and compelling justification, motivation, and guiding frameworks for thinking about how to appropriately promote and limit IP rights. Moving from Catholicism to Judaism, Jewish law, interestingly, has dealt with IP pretty extensively. At least in the past few decades, we see a large body of scholarship from many scholars that deal with this intersection. And if we look at a current writing in the field, so the main contributions that we see in this regard come from two major American scholars, Professor Roberta Kuhl and Neil Nathaniel, that explore Jewish approaches to IP law. Professor Kuhl explores the intersection between religious and secular thought with a focus on the Jewish and Christian traditions to develop a stronger moral right framework for authors under copyright law. In her work, she argues that IP law reflects an incomplete understanding because it doesn't consider spiritual motivations for creativity. She uses insights from the creation narratives of the book of Genesis to ground her argument for meaningful moral rights for authors, balanced by constitutional and public interest considerations. Professor Nathaniel has used Jewish law as lens to examine fundamental copyright law issues, including the nature of copyright and its reach. He has also made the Jewish law of copyright a focus of his study, tracing its origins and development in the historical context. His work explores disputes involving issues that elude easy resolution under secular treatment of copyright law. While Professor Nathaniel initially aimed to introduce secular copyright scholars to the unfamiliar system of Jewish copyright law, his work shifted over the years to a deep exploration of Jewish law and history, reflecting his personal exploration of his religious tradition. Moving on to Muslim approaches to IP, Bashar Malkawi is a prominent Islamic law scholar and academic at the University of Sharjah, who has written about the protection of IP under Sharia law in Arab countries. He identifies Sharia law concepts that support IP protection, which can be applied in evaluating modern expansion of IP law. Malkawi believes that Islamic law affects every aspect of Muslims' life, including IP, although the rules that govern IP in Islamic law do not resemble current IP rules. When writing about religion and IP, he is extra careful not to show that Islamic law is compatible with IP in every aspect. Malkawi relies on primary sources of Islamic law, such as the Quran and the Sunnah, and cites many verses from the Quran. He cautions that while there are issues in earlier Islamic law that dealt with IP, they cannot be quoted with modern concepts such as fair use and parallel importation. Finally, Professor Margot Bagley looked into the Protestant approaches to IP. Her work focused mainly on patent law and policy and touched upon three directions. The first one was doctrinal patentability requirements. The second was new technologies in the biological sciences. And the third was the biblical analogies informing patent policy. One of the common concerns throughout the work of Bagley was the potential for patents to result in injustice to various populations. Bagley explores the justice theme most notably in relation to biblical analogies and their applications to patent laws, such as the comparison of Christ's agrarian parables to plant patent litigation and the use of religious source materials to argue against the rhetoric of pharmaceutical companies characterizing compulsory licensing as theft. The author's exploration of these themes has been enriching, and her fate has become more visible in her work over the years. So to conclude, like this very, I would say, concise description of the literature on IP and religion, we see that the intersection between IP and religion touches upon many religions in the current legal scholarship. The scholars who study this intersection tend to take an interdisciplinary approach and are interested in making insights from religious texts accessible to a wider audience. They also often have a personal desire to explore their own spiritual beliefs and mesh them with their work. The scholars find traditional justifications for IP protection, such as utilitarianism, incomplete and unsatisfying. Instead, they turn to religious texts for a thicker and more resilient conceptual metrics. Examining IP issues through the lens of religion and faith traditions can yield rich insights that are relevant to our 21st century society. It may also lead to new approaches and solutions for some of the most challenging IP issues of our day. And the panel that I'm going to add in a few minutes is going to offer, I think, a new, fresh look at how other religions consider IP and current challenges. Thank you. Okay, so I'm really honored to start this great panel, and I want to introduce our speakers. And each speaker, as we agreed upon in advance, is going to talk for, I would say, 7 minutes if possible. And then we open the discussion for some questions to which all of you can respond. So I want to first introduce our panelists. I think I'll introduce you and you can go ahead and talk, and I'll do it one by one. So let's start with Professor Tabrez Ibrahim, who is an associate professor at Lewis and Clark Law School, and is a scholar at George Mason University Center for IP and Innovation Policy. His primary scholarship concerns law and technology and patent law, and he is a registered U.S. patent attorney. He graduated with JD and MBA degrees from Northwestern University, an LLM degree from University of Houston Law Center, and a degree in engineering from Stanford University, and another degree in engineering from the University of Texas at Austin. And he is going to discuss with us Islamic law and IP. So Tabrez, the floor is yours. Thank you.
Thank you, Miriam, and thanks to George Mason University and all the organizers. It's really great to have this. So I know we're limited on time. I'll keep this brief so as to just give an introduction to Islamic views on intellectual property. I'll start off by saying that from this talk, I'm not going to go into some of the formalities that Muslims may follow. I'm just going to talk more from a Western kind of standpoint here. So this is drawing a little bit on my existing publication that's on my SSRN page about intellectual property and patent law, but I'm going to talk broadly about IP and Islamic law. First, I'll just say there's kind of two frames with this, or two perspectives in the Islamic community. One is that there is no explicit mention in Islamic law about intellectual property. And due to that, there's a minority view now that says IP cannot be justified, and how we think about IP does not exist, or it cannot be construed within Islamic law. There's another perspective, which is now getting to be the majority, that recognizes IP, and that recognition is based on secondary sources of law and reasoning in Islamic law that construes what we think of about IP, and says that, well, anything that has what's called mal, which is an Arabic word that is not easily translatable, but basically value, can exist and can be justified. So that's sort of the starting point, that there's two different views. And the second one is getting more prominence, and there is still debate in how IP and what we think about IP, or what IP should be from the Islamic perspective, is still being debated. So that's the debate right now. And we'll add that this is a really important and timely issue. About 1/4 of the world's population is Muslim. There's many countries that follow in various levels of primacy of Sharia or Islamic law. And it's an important issue for many countries that are developing and consider IP as being important to economic development and innovation. So again, there's two views. One that says no explicit mention of it, therefore, within the primary sources of Islamic law, that is the Quran and the Sunnah, that due to that lack of explicit mention, there should not be IP. And the second one is, well, we can reason it. Anything that has value can be considered permissible. Recently, and it's only been within the last few decades, there's an international council that decides emerging legal issues. It's the Islamic Fiqh Academy of the Organization of Islamic Cooperation. It's basically jurist scholars and theologians and others that debate new and emerging issues, have recognized IP, and they've said that even though there's not explicit mention of it, it can be reasoned. IP falls within public need and public interest. They haven't given a lot of reasoning as to why IP should be justified, but they say our modern consensus-based view is that IP should exist. And with that, there is still a lot of unresolved questions that I hope to explore. There's some tensions with how we here in the US and the West broadly think about IP and how an Islamic perspective would think about it. The tensions are based on the fact that from an Islamic perspective, Islamic law considers that it's divine, infallible law that guides all of human life and society. And in theory, it should also, that Islamic law should also guide any notion of IP or however we think about IP. Islamic law also has, besides these primary sources, the Quran and Sunnah, secondary sources, and there's ways of justifying IP or implicitly coming up with reasoning to say that IP exists. But what I've argued in my paper and work in progress that I hope to publish soon is that it's different than how we think about it here in the US and in the West. It's different from the standpoint it's not as broad, it's not as far-reaching. There are some limitations, some of which are based on morality and ethical principles. There are different ways of thinking about IP, such as the prohibition in Islam of monopolization and hoarding of wealth. There's also significant public interest considerations. There are also restrictions on incommensurate benefits that come from minimal value. So in other words, little effort that gains a lot of value may be considered impermissible. And there's also notions of social justice and balance and distribution in society. So these are high-level concepts. I want to just keep it brief here and leave time for Q&A, but I want to point out a few closing things before I turn it over. One, that the majority view in Islamic modern perspectives is that IP can be recognized and can be justified, but IP is different than how we may think about it in the US and the West. And it's really a more, I think, of a balanced approach than in the US and the West. And I'll leave it there and welcome questions later.
Thank you, Tabrez. Let's move on to Professor Ayelet Hoffman-Leibson, who is an associate professor of Jewish law and Talmud at the Reichman University in Israel. She has been a visiting professor at Harvard Law School and at the University of Pennsylvania School of Law. Her first book is entitled Law and Self-Knowledge in the Talmud and was published by Cambridge University Press in 2019. She is currently at work on a second book on the Bible and legal theory. Ayelet.
So nice to be here. It's really an honor and a fascinating topic. I want to speak very briefly about intellectual property in Jewish law. As you probably know, Jewish law develops out of from a very, very early period. So the foundations of Jewish law are found in the Talmud, which was created in the first centuries from about the year 200 to the year 600 or 700, first in the land of Israel and then in Babylonia. And every concept that develops in Jewish law has to be true to these very early sources. And so one of the major problems that modern Jewish law has with intellectual property, and in fact, intellectual property is probably considered the most difficult Achilles heel in terms of matching Jewish law to modern, to contemporary reality, is that when we look at the sources in the Talmud and commentary on the Talmud, according to most approaches, there is no such thing as intellectual property. Property is actually something that is relevant only to concrete material property. And any conversations that develop around intellectual property are actually sort of grounded in something that is material. So for example, if there is a rabbinic conversation about selling the rights to a certain perfume, a smell, so they won't be only around the smell or the reputation of the perfume, it'll be about the actual concrete perfume that is being sold. Okay, so not just the smell, but the actual material object. So that's a major problem for scholars of Jewish law, and even more so for decisors who actually have to deal today with people coming to them with very complicated questions about intellectual property. And this is especially significant since most people who adhere to Jewish law are living in countries where the state law is not Jewish law. So there's a kind of tension that adherents of Jewish law feel between the modern contemporary developments of intellectual property law, which can be very sophisticated, and the difficulties that arise in terms of Jewish law. I want to speak very briefly in a few words about a paper that I wrote, which actually demonstrates how precisely the things that we might think that make Jewish law as religious law most difficult to apply to a modern contemporary system actually can be helpful to us. And I want to talk about a certain arrangement in Jewish law whereby a new problem has developed in the modern period, in the modern era, which relates specifically to the area of copyright, and even more specifically to the problem of copying only parts of a work and not the whole work in its entirety, right? So we're all familiar with, we want to see a specific short part of a video out of a big movie, or we want to listen to just one song out of an album, and we don't want to download the entire thing. And modern decisors have dealt with this problem by relying on a specifically religious principle. So we find throughout Jewish law, as I believe with any religious legal system, the idea that in some cases you don't actually need anyone, the person who is following the law is going to have a very, very strong internal conscience because of the sense that God is watching that person. And Jewish law specifically frames this idea as God can see into the heart of a person. And modern Jewish copyright has actually used this principle in order to develop the idea, to develop a distinction between cases when a person would be permitted to copy a protected work and when it would be prohibited to copy a protected work. And the distinction is based on this idea of God seeing into the heart of a person. How? How does this work? Basically, modern decisors develop the idea that a person needs to look into one's heart before determining and deciding whether to copy a certain part of a work. So let's say, for example, that there's an entire album that's out there on the internet, but I'm only interested in listening to one song. And I'm now debating, can I download this one song from this protected work or not? And so rabbinic decisors say that I need to ask myself, in an alternative reality, when I would not be able to download just this one song, but it would be either to pay for the entire album or not to listen to the album at all. Would I pay for that album? And if I answer yes, I would pay for that album, then I can't download this one song either. But if I say no, I would just forget it. I would just not listen to the album at all and not listen to the one song that I want to listen to. Then in that case, I am permitted to download this one song. Now, how do we know? How can we distinguish between these two cases? That depends on an internal conscience, which in turn depends on the idea of divine omniscience, that there's actually a God who can see everything. And so that kind of strengthens my conscience in making the correct decision, because I'm not going to lie to myself because I know that someone is watching over me. Now, in a joint article that I wrote, we suggested, and maybe I'll expand on this a little bit more in the Q&A, that even though this principle seems like a principle that is only applicable to a very religious system and perhaps something that is completely irrelevant to a modern secular system, we suggest that it can actually be imported into contemporary law through the use of big data. That big data can actually replace the role of God in the religious legal system. And big data can predict whether a person in an alternative reality would download that protected work or not. And thus, we can actually use this principle derived from religious law and apply it in contemporary secular law. I'll conclude here for now.
Thank you. Let's move on to Suraj Ongla Darum. I hope I pronounced your name correctly, Suraj. Suraj is a research fellow at the Center for Science, Technology and Society at Chulalongkorn University in Bangkok, Thailand. His concern is mainly on how science and technology can be integrated into the life world of the people in the so-called third world countries, and what kind of ethical considerations can be obtained from such relation. A large part of this question concerns how information technology is integrated into the life world of the Thai people, and primarily how such integration is expressed in the use of information technology in education. He is the author of The Ethics of AI and Robotics, a Buddhist viewpoint, The Online Self, and a Buddhist Theory of Privacy. His articles have appeared in the Information Society, AI and Society, Philosophy in the Contemporary World, and among others. Suraj, the stage is yours. Thank you.
Yes, thanks a lot, Miriam, and I'm glad to be here. It's very late at night, very early in the morning here in Bangkok. It's almost 3 a.m. now. So if I'm not as sharp as I should be, please accept my apologies. I'm going to talk about the attitude of Buddhism on the questions of IP, and I found that I am in agreement with both Tabriz and Ayelet in that Buddhism is an ancient religion, and the context, the social context in which Buddhism originated was not the kind of social context that actually gave rise to the modern conception of IP that we know it right now. So we have to do some kind of conceptual leaping interpretations. And yeah, and I agree particularly with Tabriz that not finding any specific mentions in the scripture, in my case, in the Buddhist text, in the Buddhist scripture, does not mean that Buddhism is against IP. So I'm much in agreement with this viewpoint. And first of all, I'm glad that Venerable Pandita is sharing this panel, because we can corroborate each other on the Buddhist viewpoint. But first of all, when the Buddha started to teach, to start the movement that became Buddhism, he did not want to involve his order too much on social or political issues. I mean, his order, his group of students kind of got away from their households, their villages, their cities in a certain way. So they formed their own order. They went out and some lay person granted a piece of land so that the Buddha and his students could stay, and they got together and they practiced. They did follow the teaching. So that does not mean that the Buddha was completely cut off from his society, because he quite often gave advice to kings or leaders of any communities that he found himself in on various issues. And I think that kind of set up a pattern where we look at the relation between Buddhism and the social context in which it finds itself. For example, when Buddhism comes to the West, it kind of follows the norms and the rules that are prevalent in the West. So it kind of try to fit in and try to find an answer for those who would like to come to Buddhism to find answers in our contemporary context. So having said that, what I would like to say is that we can have our own IP system that is currently practiced in the West, and is, because of globalization, it's practiced all over the world. And Buddhism, in principle, has nothing against that. And another thing is that one of the basic practices that a lay person, a lay Buddhist, is expected to follow is that is the practice against stealing. And we could interpret that precept into some kind of an injunction coming out from the religion against violation of intellectual property rights, because that could constitute stealing in a way, and as a result, that is against the second precept, against stealing. So that is one. And in the social context where IP is encouraged because of various reasons, and Buddhism has nothing against that. It has a criticism of the whole IP system only in the case where some some groups are using IP to gain, unfair advantage against other groups, and that would, create some tension, and that is a cause for criticism. So for the interest of time, I would like to stop here, and we can have our discussion, and then we will return to this later if we like. Thank you.
Thank you, Suraj. We will turn to our last speaker, Ven Pandita, who is a Burmese monk who has lived in Sri Lanka since 2004. Before he came to Sri Lanka, he got his monastic education in Burma. He also studied Sanskrit poetics for 2 years in Varanasi, India. In Sri Lanka, he was a student in a PhD program at the Postgraduate Institute of Pali and Buddhist Studies at the University of Kelaniya. And since 2011, he began to publish his research in several research papers in the Journal of Buddhist Ethics and other journals. The stage is yours, so let's hear what you have to say. Thank you.
Can you hear me clearly? Okay, then I'm afraid my accent will be problematic for you. So please permit me to some slides. My talk will be quite short. So I have to agree with Professor Suraj that Buddhism doesn't like to be involved with the social or political issues. So, in fact, we have a Buddhist ethics only, no Buddhist law. This is, I think, the difference from Jewish law or Catholic law, etc. Because Buddhism only advocates ethical rules or precepts or ideas, but know how to implement them, such ideas in the society. For example, Buddhism says, thou shalt not kill. You must abstain from killing. But how about the military? Buddhism never says anything against the military. It shows that Buddhism doesn't really bother us about the social political issues. So, and at the same time, when the Buddha appeared in the world, there was no concept of IP yet. So, if Buddhism has anything to say about IP, it means that we must infer from the present scriptures and the commentaries. We can only infer. We cannot find anything explicit in the original sources. So, please allow me to use some slides here. So, analogs to IP in early Buddhism. So, first of all, we must first I will give a summary of what I wish to say here. Early Buddhism deems private property itself as the consequence of a sin. The details will follow. Therefore, use IP the same. So IP is not a sin itself. It's only the consequence of a sin. But the private property or IP, they really exist in the society. It means that Buddhism should have some ways to deal with these entities. So, in this context, analogs to IP can be found. So first, we have to go to the original sources. The Aganya Sutta in Digha Nikaya shows how the private property has come into being in the human world. So that sutta describes how moral decay has caused human beings to fall from their heavenly lives into the present, comparatively, the voice is speaking, the suffering in our world. So according to the account found in that sutta, in those ancient times, rice is the staple food. So, but the people don't need to grow any rice. Rice was growing in the wild. So, whenever we want to eat, we go and harvest the rice grains. After harvesting, the rice is automatically refilled without any human care. So after living in that way for a long time, one person chose to become lazy. So normally when they want for breakfast, they harvest only for breakfast only. So for dinner, they go out again. So before the dinner time, the grains harvested for the breakfast had already been refilled. So when that person became lazy, he chose to harvest for a share of 3 or 4 days. Soon other people will follow suit. When that happened, when people began to hoard resources, then all those grains harvested will not be refilled anymore. So they come to they have to face the scarcity of resources. So at the time, people chose to divide the common property into the private possessions. Each person will own a plot of land in which rice was growing naturally without human care. So we should know here that the sin is unnecessary hoarding. So the rising of private property is only a consequence of that sin. But whether we like it or not, the system of private property is already there. So how Buddhism deals with that situation? So donations is a first of 10 perfections, and it is a meritorious deed that adopted by almost all Buddhist people. So donation donation is possible only with private properties. When everything belongs to everyone, then it's not possible to donate, right? So we should know that even though private property is a consequence of the sin, still we can do something good out of it. Also, abstinence from theft, adena dana virati. This is a part of morality. It also can exist only when theft is possible. When everything is common property, it's not possible to steal. Now, intellectual property is a modern extension of private property. So it is also a consequence of sin. That is to say, when the printing presses arose in the world, people came to started to abuse the creations of authors and researchers. If I had if I have a press, I can publish any book of anyone else. I can make profit without sharing any benefit with the author. So to prevent such a situation, the copyright rules, we all know that. So I think I'm justified in saying that IMB is the consequence of the sin too. Then, from this situation, we can find how Buddhism would deal with the IMB. IMB is a legitimate object of donation. Before the rising of IMB rights, it's not that there's no way to donate IMBs. But now we can. If I'm an author, I can donate my work to the public domain. And also, abstinence from infringing the IP rights of others can be deemed part of morality. Of course, Buddhism doesn't explicitly say that. This is only inference. Then we go on to the analogs of IP in Buddhism. So to do so, I would like to divide the rights enjoined by owners of intellectual property into three types. First, right to credit. Second, right to identity. Third, right to monopoly. So depending on the type of IP that you own, you can enjoin one or more of these rights. So first, we deal with the right to credit. So the compulsory acknowledgement given to the creators of ideas or expressions and the discoverers of information whenever someone else makes use of their work. A failure to give proper credit results in plagiarism. So analog, the precept against lying serves to protect the right to credit. So lying here means that not only when you say a lie, not only when you tell a lie, but also when you fail to express what you should, it can be deemed a kind of lying, especially in monastic law. So when we fail to give proper credit to other people's ideas or expressions, then it's a kind of lying. So the Buddhist precept against lying serves to protect their right to credit. Next, right to identity. Exclusive rights of business to its trademarks and brands. So here also the analog is the precept against lying. If my company makes products using the brand of another company, then I'm practically lying. So the precept against lying serves to protect the right to identity. Next, right to monopoly. A time-limited monopoly of copyrights and patents enjoined by their owners. this I cannot find any analog in Buddhist text. No analog. So what we can find is maybe at the time of the Buddha, they might, I think they are trade secrets. Because the evidence is that in the Digha Nikaya, there's a term, Ajariya Mukti, a teacher's fist. This is a secret in the art or in the craft of a teacher. He is supposed to transfer this secret only when he is dying. He will transfer this to his favorite disciple. Before his death, none of his disciples can access their secret. In that way, the teacher will protect his own interests. But the Buddha explicitly said that he did not have such a secret. But he never said anything against such trade secrets in the mundane world or in anything else. He didn't have such a secret only in his teaching. So we cannot say whether trade secrets are good or bad in Buddhism. And then I'd like to answer some questions raised by Professor Miriam. For AI, for Buddhism, there's no issue, no problem with AI, because we believe that intention is karma. So if a given artificial intelligence goes beyond what's intended for it, so any rogue actions of such an AI is not a moral responsibility of the AI programmer. We can say that if such a bad thing happened, we can say that this programmer is not good enough. But we cannot find any moral issue with him. Another issue is the incentive versus access. For us, this is not a moral issue. It's only a matter of implementation. Depending on the time and place, it might be different. My talk will end here. If any questions you may ask.
Thank you so much. It was really, really interesting. And I have some follow-up questions for all of you and also for you. So what we are going to do now, we are going to have a discussion of some questions, and you may also make comments about some of these questions or others. And after we are done, we are going to dedicate 15 minutes for a Q&A for questions from the attendees. So whoever wants to post questions, you should and you can do it now. I saw that Joshua Sarnoff, for example, posted a question, so you may do so. And then in the end, we are going to dedicate time for it. So please do it. I wanted to raise some questions to all panelists, and each one of you can address some or all as you see fit. So some of the questions that some of you addressed so far was how the different religions approach IP questions. What rules or approaches address questions pertaining to creativity or innovation? And I think some of the things you have mentioned really briefly can be really interesting. So if you want to say more about that, it can be great. Another question that I wanted to ask you was the extent to which religions are responsive to new technologies and willing to accommodate those technologies. So AI was one example, but we can think about other examples, biotechnology, nanotechnology, and others. I also asked about international health crisis. Think about the recent world crisis with the corona and pandemics and compulsory licensing and access to vaccines and so on, all the debates that we had during this really hard time that all of us, I think, went through. How would the different religions approach that? And the questions of access to drugs all around the world, third world countries, and so on. And keep in mind that our panel is dealing with analogs. So to the extent you can identify analogs in other systems, how do they work and how do they coexist with Western notions of IP in different cultures, how they shape IP protection in those cultures, and how do they influence or responsive to developments of local cultures. You may elect to address some or all of these questions. So we can start by opening it for all the 4 panelists. So who wants to go first? Please feel free. Tabrez, do you want to address some of them?
Sure. Great questions and really excellent discussions here. I kind of framed the problem from the Islamic perspective and gave some context, but I wanted to go a little bit deeper now in this. So to echo some of the earlier thoughts from the Jewish faith, there's some similarities between the Abrahamic faiths in Islam, and I wanted to add a little bit more on that. So to address your first question, how IP can be recognized? Well, from sources of law, and private property does exist in Islamic law. In primary sources of law, there's a lot of mention of private property, and it's justified. But there's a different way of thinking about it from the Islamic perspective. So one is the fact of this God consciousness to have about life being temporary and constantly thinking about from a spiritual view or how one would be judged from this temporary life. And that includes use of private property and just what may cause harm to others. So while private property is recognized and championed, there is still this God consciousness to have. Another thing to consider is just the source of where creativity, innovation, inventorship, and the like of how we think about intellectual property here, where it comes from. In some ways, it is a human endeavor, but everything comes from God in that perspective as well, from the Islamic perspective. So there's some recognition of that, as well as recognition of those in society, parents, others that have helped shape someone. So there's more of that thinking while still recognizing private property. And one more thing I will add is that the excesses that may be causing harm in society here in the US and other Western societies, there's limits to it. So there's ways of purifying and not having a sort of unhealthy obsession with hoarding or possession. And so sharing things or having donations as has been mentioned in other traditions would also exist in Islamic perspective. So it's like such as zakat, sort of donation to others in need, and other ways of purifying from excesses. So there's 3 things I'm adding here from my prior comments that on top of recognizing private property, the Islamic perspective would also embody God consciousness, 1, 2, recognizing the source of creation and innovation and inventorship being from a higher state than just human thinking, and then 3, limits to excesses and distribution through donations and other mechanisms to prevent the sort of hoarding and high obsession in an unhealthy way with possession and excesses.
Thank you, Tabrez. Others, Ayelet?
Yeah, thank you. Really interesting to think about, how the different religions interact with one another. It's interesting because I think, in Jewish literature, at least early literature, there's a distinction between legal literature and ethical literature. So while in ethical literature, there might be a little bit of, thinking about, the problematics of accumulating property. In legal literature, we don't see that at all. I think that there's, it's very, very matter of fact and just like accepting that private property exists. And now, how do we deal with it in the best way, in the way that would allocate property in the fairest way. I want to also respond to one of the issues that Miriam raised about how do religions respond to technology? And maybe I'll say a few more words here about my argument earlier. First of all, I think that what we see in Jewish law is that there isn't an a priori objection to technology, but there isn't also, an assumption that we're going to adopt any technology, but rather really like each technology is sort of examined by rabbinic decisors to investigate, is this a good thing or a bad thing? What are the values that are underlying this technology? How is this technology going to serve different values that are found in the religious legal system? So, since we're on a panel about IP, then we see this very, very strongly in this field, because really the development of intellectual property in Jewish law only started with the origins of the printing press. And because Jewish legal culture is such a textual culture, and books are really at the focus of this culture, then the technology of the printing press was adopted very quickly and very wholeheartedly. And, the idea that you don't have to sit and copy a book so laboriously, but that you could just, disseminate your ideas more widely was huge and was really completely culture changing for Jewish law. But then it created all these new problems, which really arise for the first time in this period about, what happens if a person takes all these beautiful ideas of Jewish law and disseminates those ideas as his own, right? Not giving attribution to the correct person, or even, what happens if someone just takes the actual material work of laying out the book and then, uses that to print new books. So many of the questions of Jewish law arose out of a change in technology. But I think in the modern period, we see, certainly like in the realm of medical issues that are determined by Jewish decisors, then we can see a lot of value judgments that are made. So for instance, if we're talking about IVF, for instance, then decisors will debate, what will this be used for? Will it be used for the value of, increasing, growing Jewish families, or will it be used for producing families that are, kind of anathema to a conservative decisor? And in this context, I want to say something about the proposal that I discussed earlier, which is basically to use big data in order to determine whether a person would pay for downloading copyrighted material from the internet. Right, big data is basically like bundling of a lot of information that's out there about us, that we leave a digital trail wherever we go. So big data is basically bundling of that information. And the idea is, I hope I can explain this quickly now. It's a bit complex, but the idea is basically that, someone who produces a work would be happy with this solution because it would mean that that they would be able to create personalization in the pricing of their product, meaning based on big data, I, as a creator, would be able to know what exactly it's worth for a person. Would they be willing to pay, you know, just a very small amount, just a few cents to be able to download this one specific song, let's say, or would they be willing to, you know, pay a larger amount? And that way I can tailor the pricing. So obviously it's great for me as a creator, but it would also be great for people who are only willing, you know, are basically not willing to pay in order to download a certain creation from the internet. And if big data could predict that if they had to pay for it, they wouldn't pay for it, then we suggest that even if they do download this copyrighted work, they should be exempt from responsibility and payment. So it's a kind of win-win situation that I think, you know, there's no reason basically for Jewish law not to adopt this idea. And we suggest that even beyond Jewish law, even, you know, contemporary modern law can also adopt this proposal.
Thank you, Ayelet. But when you think about your model, I remember when I read your paper, I was wondering about the effects of such a regime eventually, because as time goes, it would be, I would say, more useful to adopt this tendency not to pay for anything. Like in the long term, it makes more sense to adopt a norm that says, I don't want to pay for anything, so I won't be like big data won't catch me as someone who needs to pay. So what is going to be,
right?
You know,
I mean, I think that's the beauty of big data. That's why we compare it to God, basically, because, you know, our digital trail covers so much of our life that it's actually something we can't like fool the big data, right? So we can't suggest, you can't decide that you won't pay for something. It's actually big data is predicting whether you would pay for it in an alternate reality when you couldn't download this copyrighted material illegally. And so it's not something that you can hide, because big data is just putting together many, many components that it kind of knows about your life. And it's not something that you can avoid. So in that sense, it's similar to God, who is, you know, all seeing and can see basically all aspects of your life.
Interesting. So Raj, do you want to address some of the questions? I saw you wrote a comment, but maybe you can address it now if you want.
Yes, thanks a lot. I'm thinking of the example of the Japanese woodblock that Sandra has introduced to us earlier in the conference. I've been thinking of whether there are analogs to that kind of Japanese woodblock in Thailand. Well, I am thinking of what I am thinking of instead is mural paintings in Thai temples. There are a lot of very beautiful mural paintings, and almost all of these paintings are unsigned. We do not know, especially if they are from many centuries ago, we do not know who the painters of these beautiful paintings are. And the system at that time was that the paintings were employed either by the king or the princess or the temples, and they worked for their patrons, and that was how they earned their living. It was only about a century ago that artists, Thai artists in Thailand were able to support themselves, you know, on their own. I mean, not being clients or not being employed by the princes or the nobles. So in that very old system, and we were talking about incentive, right? The artists did not have the incentive to. I mean, the situation was a bit different from Japan, because Japan has the system where tradings and the merchant classes are kind of gaining dominance, but not that much in Thailand. So the social systems are a bit different. So when we think about whether there are analogs, I mean, we have to distinguish between what is there in the text. That's one on the one hand, and what is the social conditions. For example, the condition that led to a lot of anonymous mural paintings that I have just said, and the conditions, when Thailand started to interact with the West and the burgeoning of the middle class and so on, the situation where artists and novelists and writers were able to support themselves through their creations, which of course, made copyright laws and IP laws necessary. So we perhaps should distinguish between these two. But the point is that when we try to find whether there are analogs or whether interpretations could be made, for example, on Buddhist scriptures to support this modern system, it's possible, especially in Buddhism, as I have just briefly said earlier. And in order to answer Miriam's question, the first question is whether Buddhism is responsive to new technologies. It's very responsive. If you look at what is happening in Japan, there are a lot of developments of robots, and there are developments of robot monks, robots acting as monks, and these robots are put inside of a lot of temples in Japan, and they could recite the text and so on. So that shows the attitude of the people. And in Thailand too, people are in general not against robots. And there are a lot of talks coming out right now on AI and whether AI will take over our jobs, the same kind of talk that is happening all over the world. But in general, people are trying to find ways to use AI for their own benefits, for their own living. So this kind of talk, finding ways to use AI to gain personal benefits, kind of, is the dominant discourse in Thai society. There are certain groups of scholars and students who are critical of AI, but still, not as much as the other group. So that is how Buddhism or Buddhist society is responsive to the new technologies. And as for the question of how Buddhism addresses the incentive versus access debate in IP, well, the idea is that as long as it provides benefits to society, Buddhism can be kind of a consequentialist in a way, but not in a kind of a denuded way that modern utilitarianism is. So anything that leads to fulfillment of oneself or kind of an alignment of oneself with nature would be good and would be the kind of a goal that could decide which action is good or bad. So as soon as, or as long as the incentives are there in order to benefit society, then the incentive side, that promotes IP protection is good. But as long as there is a need for access to such an extent that if that access is denied, that would create, tensions and suffering and unnecessary pain and so on. That would be a case for criticism also. So we need to look at this debate on a case-by-case basis. And that, I think, is in line with the spirit of Buddhism, which, by the way, has a lot of in common with the virtue ethics tradition in the West. So that leads to the last question that Miriam has given me earlier about compulsory licensing. About 15, 16 years ago, Thailand was very much in the world news because it declared compulsory licensing of certain pharmaceuticals. That has led to a lot of debates and discussion. But the rationale given by the Thai government was, not anything Buddhist at all. They were thinking about the interests of the population who would lack the access to these important pharmaceuticals, where IP system were in place, because that would have made the price of the drugs too high. That was the rationale. But if we look deeper, because 95% of the people in Thailand are Buddhist, we can find Buddhist justification for that, which does not mean that Thai society or Buddhism, in general, is against IP, because, as I have said, violation of IP actually constitutes stealing, which is against the precept, which is against the normal practice of a Buddhist when they want to reach the eventual goal. So those are my answers that I have kind of prepared. Yeah. Thank you.
Thank you so much. Ven Pandita, do you want to add some things?
Actually, I think I have written a paper on intellectual property, and I think I proved in that paper that infringement of IP, especially copyrights and patents, is not equivalent to stealing, at least in a Buddhist sense of theft. So in this case, I think I differ from Professor Swaraj. So in my opinion, the copyrights and patents, at least from a Buddhist point of view, infringement of copyrights and patents are different from real stealing. I think
It's interesting. It's the same view in Judaism. It's interesting to see parallels across religions.
Yeah. So what happens is that, and now I have to talk a little about my country, Burma. So in Burma, we have the so-called Buddhist law. Buddhist law means that a law that traditional law that has been influenced by Buddhism, especially by the monastic law. So in monastic law, we, especially in dealing with such kind of the crime of theft, the principle is that we deal with the immediate parties. That is to say, if someone donates something to me, then it is legal to accept. So suppose if that person has stolen that property from another person and then donate to me, then it's not my problem. It is the donor's problem, not mine. In the same way, suppose I'm buying a pirated copy of a book from a shop. As long as I pay for the book, that piracy is not my problem. So it's that the shop owner's problem. So at least this is how monastic law works. So when the monastic law influences the Buddhist society, what happens is that we also have a copyright law and patent laws. So if you refrain from when you respect copyrights and patents, you are a lawful citizen. It doesn't mean that you're a good person. That is to say, copyrights and patents do not have a religious value. So actually, it's the situation in my country. I don't know about Thailand. So
Interesting. So we can move on to questions from the attendees of the conference, and I want to raise the questions that some of the participants raised. Joshua Sarnoff from the poll. Hi, Josh. Had a question for Ven Pandita. He asked if there is a moral obligation to donate, is that obligation socially enforceable? In which case there will be no possibility of infringement because the IP must be donated to the public domain. If not, what happens if the moral obligation to donate is not fulfilled, only bad karma? What's the answer for that?
like that you see, I don't mean that IP right must be donated. I didn't mean that. What I mean is that it is possible to donate IP if there is the concept of IP in the society. Before then, before the IP rights come into the society, it doesn't make sense. If everyone has access to any intellectual creation, then it's not possible to donate because it belongs to everyone. But once the intellectual property becomes a commonly accepted notion in the society, then you can, it's possible to donate IP to someone else or to the public domain. It's what I meant.
Okay, interesting. Josh has the same question for Tabrez. Go ahead, Tabrez.
Yeah, thanks. It's an excellent question. Really made me think. And so I'll say a few things on this question from an Islamic perspective on how you may have some sort of donation or charitable form. So there's a couple of things. One is, I think from an Islamic perspective, the government would have a greater role and they can require certain things, such as donations, including of IP. And there's also more of an individual level perspective on this. So I can give a couple of concrete examples on this. So if, and this is being theorized and worked on, so I think it's an excellent question Josh asked. If it was required to donate some form of IP, let's say patents, there may be large companies that say, okay, if you require similar to zakat, that obligatory donation by Muslims, 2.5% of one's wealth every year, and then companies might just donate the most useless patents, for example, and it may not be optimal for society. So there could be some mechanism like that where the state requires something. Another thing is more at the individual level. For example, there may not be enforceability, but if everyone on the aggregate in the society thinks about this, every company, every university does this from an optional standpoint, the thought is from an Islamic perspective, then we would all benefit. So there's some sort of benefit when everybody seems to purify themselves. And it's just on that person. So there may not be any requirement. So in Islam, there's also this notion of sadaqah, it's sort of a optional type charitable thing. The idea is that it's somebody knowingly and willingly with the intention of pleasing the creator is giving sadaqah, performing charity. The idea is all of society benefits in some way. It's not only to purify oneself, but also to benefit everybody else. But as far as how to administer this, that's something I'm trying to work on myself. And there's different ways that it could be done. And I think it still needs to be discussed.
There was another question for you from Masami Kawase. The question was, Muslim religions prohibits idolatry. In some Muslim countries, are there religious regulations or limitations for trademark of a picture or copyright of a picture?
It's a good question. So some countries have this in the prohibition against idolatry, which is considered the greatest sin from Islamic perspective, is to not have oneness with God. But the idea is some countries do prohibit this, but these are just being shaped. So these are very nascent principles. So it would require a fatwa, a legal ruling from those that are able to give rulings. And I found, for example, Sri Lanka has this. I don't know all the laws in certain countries that have large Muslim populations. And there's some other countries that have this prohibition, but others have not explicitly stated this. By comparison, for example, on the patent or trade secret side, there's prohibitions in some countries and some majority populations against alcohol and other prohibited type things, that is getting patents on formulations and things like that. So this is still being shaped, but it's not become prevalent in all Muslim countries and would require some sort of fatwas from those that can give legal rulings on these.
Interesting. A question for Ayelet. Back to the question of big data playing the role of God, Professor Hoffman-Leibson, do you not see a problem in that some content or data do not reflect actual intention, reality, and may be easily misinterpreted? For example, often content is a pose or is a propaganda or is insincere, or may not have been manipulated, or may have been manipulated. It is not necessarily as it might appear. Conscience read by God is direct. Content read by AI is derivative and may not reflect the first order of intention or creation. What do you think about that, Ayelet?
Thank you. So I think this is what's a bit hard to wrap our heads around in terms of big data, that big data is actually something that's quite hard to manipulate because it aggregates so many different data points about us that we can't really, there's no way for us to control it, right? So if we're looking at, where I live and what purchases I make with my credit card and when do I go to the supermarket, and like hundreds of different data points that are aggregated together and really end up reflecting quite an accurate portrait of a person's behavior and being able to predict that behavior. However, I will say that there is some critique of using big data in legal regimes at the moment due to who is writing the algorithms that are doing this aggregation, and basically how is the algorithm attributing significance to different data points. So there's been a lot of critique of this from a feminist perspective, for instance, that the algorithms are being written by men mostly, and therefore, may in certain cases not take into account what a female algorithm writer would attribute more significance to. So, there is certainly fine tuning to be done. We're putting out, the basic idea, and I think we're going to, it's an interesting idea to explore beyond the reaches of this panel. To what extent can we think of big data as replacing a divine role in legal systems beyond IP and into other areas as well?
So thank you very much, Ayelet. There are some more questions, but unfortunately we have to end our panel. So I want to thank Tabrez, Suraj, Ayelet, and Ven Pandita for a great panel and really interesting insights. I learned a lot. I must attest that I wasn't aware or knew about many of the things you said. And I think it's really, really fascinating, especially to see many similarities amongst religions. Like I found many things in common for with Buddhism and Judaism and Islam, which is really interesting. And I think we have a lot to learn and to keep studying, I think, in the future. So thank you so much for the panel, and thank you, Sandra, for giving us the opportunity to hold such a panel. Thank you, and have a good evening, all of you. Thank you so much.